Can a power of attorney access bank accounts? Have you ever wondered if a power of attorney can access bank accounts? This question is important for anyone involved in estate planning or managing finances for a loved one. Let's break it down. A power of attorney is a legal document that allows one person, known as the agent, to act on behalf of another person, called the principal. This can include managing bank accounts, but it all depends on the specific powers outlined in the document. First, it is essential to understand the scope of authority granted in the power of attorney. The document must clearly state that the agent has the authority to manage bank accounts. This can be broad, like in a general financial power of attorney, or limited to specific actions or accounts. If the language is unclear, banks may hesitate to allow access. Next, banks have their own policies regarding power of attorney documents. They typically requiring the original or a certified copy of the document to verify its validity. Some banks may even have their own forms or specific language they want included in the power of attorney. It is also important to note that banks can be cautious about accepting older documents, fearing that the principal's intent may have changed. Another point to consider is the type of power of attorney. A springing power of attorney only becomes effective upon a triggering event, such as the principal becoming incapacitated. In these cases, banks often requiring proof of that event, like a statement from a physician, before granting access. If the bank account is held in a trust, a power of attorney does not grant access to that account. Only the trustee or co-trustee has authority over trust accounts. Legal requirements for a power of attorney can vary by state. The document must comply with state laws, which may include proper execution, witnessing, and notarization. This ensures that the document is valid and accepted by financial institutions. From the perspective of elder law and estate planning, a power of attorney is a vital tool for managing non-probate assets like bank accounts while the principal is alive. It allows for smooth financial management without needing court intervention. However, it is crucial to draft the document carefully to ensure that the agent's authority is clear and that banks will recognize the power of attorney. Practical steps include consulting an attorney to draft or review the document to meet legal standards and bank requirements. It is also wise to inform banks in advance about the power of attorney and provide them with the necessary documentation. Remember, the agent has a fiduciary duty to act in the principal's best interest when accessing bank accounts. In summary, a power of attorney can access bank accounts if the document grants that authority and the bank accepts it. This makes it an essential instrument in estate planning for managing financial affairs effectively.